Okay, this is Somnia Inc. and Resource Anesthesiology Associates of Michigan PC versus Capital Area Anesthesia PC et al. Docket number 21-35CB. This is the time set for hearing on non-party McLaren Greater Lansing's motion for a protective order and to quash the plaintiff's subpoena. And I'll take appearances from you first because it's hard to know on Zoom who goes first. First, we'll have the moving party McLaren, or non-party McLaren Greater Lansing. I'll take the appearance.
Good afternoon, Your Honor. Scott Eldridge on behalf of McLaren Greater Lansing.
Thank you. And then for the plaintiff?
Good afternoon, Your Honor. Roger Myers on behalf of the plaintiffs, and I've got Lena Gonzalez with me as well.
Okay. And for defendant, is there anybody?
Yes, good afternoon, Your Honor. This is Stephanie Jones representing all the defendants in this case.
Yes. Okay, then we will get going. And Mr. Eldridge, your motion, you may go ahead.
Thank you, Your Honor, and may it please the court. In our motion that we filed some time ago, we asked the court to quash entirely the plaintiff's subpoena, an ask that I intend to modify slightly today, and to which I'll get in a few minutes. But most notably because this matter relates to the fact that McLaren is separately engaged in arbitration proceedings initiated by the plaintiffs, including RAM, or RAAM, which stands for Resource Anesthesiology Association of Michigan, asserting a breach of contract claim. That arbitration proceeding is governed by an arbitration agreement that's referenced in the briefing before you today, Your Honor, that places strict parameters on the discovery phase of that truncated arbitration proceeding. Specifically, the arbitration agreement limits RAM and McLaren to 40 total interrogatories each and 2 depositions on each side, all of which has occurred as of last week. The limited discovery in the arbitration proceedings is therefore over, and we're now gearing up for an arbitration hearing that's set to start the first day of the week of May 24th. We're gearing up also, of course, for many pre-hearing matters that have to be addressed, including pre-hearing briefs, exhibit exchanges, motions in limine, discovery-related motions, prepping witnesses, just to name a few, of course. Under the arbitration agreement, and most importantly for purposes of our motion today, RAM and McLaren agreed in no uncertain terms that neither party would be able to serve or have to respond to requests for documents, which we all know can be costly and time-consuming process in any discovery phase. Now, neither I nor Mr. Myers on behalf of RAM negotiated the arbitration agreement. And so I don't think either one of us is precisely sure what the rationale for that limited discovery was, but I can venture to guess that it's meant to set the expectation of the parties to not to burden one another with costly document searches, document reviews, and document productions. In other words, to save on costs and to streamline the arbitration proceedings a little bit. Yet here we are, McLaren is being asked to do just that, respond to costly document production, which with respect to the pending arbitration, just over 2 months away, places McLaren at a significant disadvantage if required to undertake that work in advance of the arbitration hearing, which is what RAM is asking and in fact demanding. Now, with that backdrop, Your Honor, I told you at the beginning that I was going to slightly modify our ask today, and that's because I think there is a reasonable solution here that will satisfy everybody. And it's a solution, Your Honor, that I actually proposed to RAM's counsel yesterday to avoid today's hearing altogether, but it was rejected. And so here we are. And it was rejected for reasons that I don't quite understand, given the infancy of this civil litigation, to which my client, McLaren Greater Lansing, is not a party. First, I'll explain the proposal as quickly as I can that I presented to counsel yesterday and I'm presenting to the court today. And then I will explain why I believe McLaren's proposal makes the most sense under these particular circumstances. So first, the proposal. We propose that in advance of the RAM-McLaren arbitration hearing set to start on May 24th, and it's going to be roughly a 4-day hearing, counsel for each will work together like we normally would under typical circumstances to pare down what we perceive to be broad requests directed at us through the subpoena to a manageable scope, and also come up with search terms that the parties can agree upon. That is, again, to limit the burden on McLaren as a non-party to this civil litigation. Then the second point we propose is that McLaren will then start its search and review of those hits after the close of the parties' evidentiary proofs in the arbitration proceeding. That way, we honor the arbitration agreement's intent to not require either party to have to engage in costly discovery production before the arbitration. And third, we will work expeditiously thereafter to produce responsive documents as quickly as we can. And that was the precise proposal that Ram's counsel rejected yesterday. But we think it's a reasonable solution and one that this court should adopt at the end of the day today for a couple of reasons. First, it's one that balances the interests, we think, of all involved, taking into account, as I think we must, Your Honor, the plain language of the arbitration agreement between Ram and McLaren that, if honored, excludes document production altogether. If McLaren alone is obligated to respond to document production requests related to the arbitration, as the subpoena purports to demand, it places McLaren at a disadvantage for two reasons. First, it would be the only party to the arbitration obligated to produce documents and work toward producing documents when Ram and McLaren agreed expressly not to do so. Second, it forces McLaren and its attorneys, of course, to spend valuable time searching for and reviewing documents related to this civil litigation to which it's not a party, instead of preparing for the arbitration hearing, which Ram and its counsel will have the luxury of doing because McLaren, of course, cannot contractually seek document production from Ram in connection with arbitration. So in short, our proposal creates, I think, a level playing field for the arbitration without prejudicing Ram or Samia in any way, and without disrupting this civil litigation in your docket, Your Honor. This litigation is in its infancy as far as I understand, including that no scheduling order has been issued to date. In fact, Your Honor, I can't imagine any real urgent reason why Ram needs McLaren's records before the end of, say, May, which is when the arbitration will have concluded. At least the proofs of the arbitration being placed into the record will have been concluded. When I asked Ram's counsel yesterday what the rush might be, he didn't articulate any urgent need for the documents, such as an upcoming deposition. So it appears to us that it's really being forced upon us for no other reason than to disrupt McLaren's ability to adequately prepare for the arbitration. Further, Your Honor, all parties, you should know, to this civil litigation in front of you and to the arbitration just agreed yesterday to explore a global collective mediation through a facilitative mediator, further obviating the need for McLaren to spend time and effort now searching for, reviewing for potential responsiveness, what we anticipate to be a voluminous set of records. Now, in fairness, Mr. Myers, on behalf of Ram yesterday during our call, did offer to accept responsive documents immediately upon the close of the parties' evidentiary proofs at the arbitration hearing. But that might eliminate one concern we have with respect to the arbitration agreement limitations on discovery, but it doesn't alleviate the other concern that I've already articulated, Your Honor, that if we're forced to, as Mr. Myers tentatively agreed to yesterday, to produce those documents in response to the subpoena immediately after the close of proofs, that would still force McLaren and its lawyers to spend all of that time attending to document production in this civil litigation when McLaren and its lawyers should be preparing for the arbitration, like Ram and its counsel, again, will have the benefit of doing. So, Your Honor, McLaren is not refusing to respond to the subpoena ever. It simply wants to realize the benefit of its bargain vis-a-vis the arbitration agreement to not have to engage in document production at this time. Ram will get responsive documents. We're just asking for a pause in that process to not unfairly disadvantage McLaren in the arbitration proceedings. Michigan Court Rule 2.320, if I'm citing it correctly, Your Honor, gives this court, 302, subparent C, subparent 2, gives this court the power to control the cadence, timing, and scope of discovery. And Your Honor, McLaren simply asked the court to exercise its discretion as justice requires to issue an order consistent with the compromise that I've outlined here today. Unless the court has questions, I'll yield the virtual podium as it may be to my fellow counsel.
I don't think I have any.
Thank you.
Mr. Myers?
Thank you, Your Honor. I'm certainly going to respond directly to Mr. Eldridge's thoughts about the proposed compromise and why I didn't think that that was appropriate. But I think it'd be helpful to just have a little bit of backdrop. We commenced this case January 20th or 21st. It was one or the other days, and I don't remember the exact date. We served our subpoena on February 23rd, so about a month later. The return date on that was March 9th. Instead of documents on March 9th or a commitment to produce on a rolling schedule or anything like that, we got this motion to quash, which was scheduled to be heard on April 1st. On April 1st, we had a deposition in the arbitration, and Mr. Eldridge, his partner, Mr. Murkowski, and their associate, 3 attorneys, attended that deposition, but cited the deposition as a conflict, making it impossible for this motion to be heard at that time. So they pushed the motion to today. So here we are, 5-6 weeks after the subpoena, talking about whether we're going to get documents. And when Mr. Eldridge proposed his compromise yesterday, my initial inquiry was, look, are you proposing to produce documents at the close of the arbitration? Because although I disagree with him about what the arbitration agreement does, I understand his concern about fairness and informational advantage and things. So I'm not denigrating that. But the arbitration agreement doesn't say anything about court discovery in a separate proceeding. It talks about discovery in the arbitration. So trying to be fair, I said, what is it that you're offering me? Are you offering to give me the documents at the close of proofs, or are you offering that that's when you're going to start working on the subpoena? And he said the latter. And my concern with that is this. So assuming that the arbitration is not delayed again, it should have started next week, but there was an illness. And so we got pushed, and I agreed to that. I'm trying to be very reasonable here. But now we're set to go for May 24th. And I certainly hope nothing else happens between now and then, but I can't predict the future. If that all works, at the end of May, we'll close the proofs. And then if they start their searching, I'm not going to have documents until mid-June, maybe even later than that. That's another 2 months from now. So now we're looking at 4 months after a subpoena has been issued before I even have documents. And I really have no commitment other than they'll start. And so my response to Mr. Eldridge was, look, I hear you when you say that that this case is in its infancy, but it's not in its infancy because of anything that the plaintiffs have done. We served initial disclosures and discovery with the case. We've tried to move forward as soon as with the complaint and summons. And we've tried to move forward expeditiously. And the reason that it's in its infancy is because we got hit with first a request for an extension, which we agreed to, and then a motion to stay, which we had to brief and argue, and the court decided recently, and then this motion to quash. And it strikes me that the idea that the case hasn't gotten very far because everybody has put roadblocks in our path is not a very good reason to allow further delay. So, it was one thing in terms of a reasonable compromise to say, look, I will work with you to talk about keywords, custodians, all the things you need to do to make sure that this is efficiently done. And then you do the work and you give us the documents at the close of proofs. That has a ring of fairness to it. But not getting started until then, that didn't strike me as a reasonable compromise. And I guess I really want to address the notion that there's some sort of unfairness to the hospital being required to engage in discovery during the run-up to trial. And I said this to Mr. Eldridge. I don't know how many cases he has on his docket. I've got several, and I don't have stays in them because I've got a case getting ready for trial. I will be doing depositions in other cases while I'm prepping for this trial. I'll be doing document production in other cases while I'm prepping for this arbitration. I'm certain that that's true with Mr. Eldridge, and that's why we staff cases with multiple people. Miller Canfield is a great firm. They have lots of lawyers. I also recognize that lawyers aren't entirely fungible, but the notion that they're unable to simultaneously prep for an arbitration in 5 weeks and also do some document discovery, that strikes me as not entirely realistic. And I think it's important, Mr. Eldridge said voluminous records. So I really want to focus the court on what it is we're talking about. It's a very, very narrow time frame. CAPC gave its notice of termination on November 23rd, 2020. McLaren Greater Lansing said that the contract was canceled with us on December 8th. The majority of our requests are focused on a 3-week period. So it's a very short window in terms of information that's needed. And, I've done a lot of e-discovery, and, I know that there are sometimes hard keywords to work with, and sometimes they're pretty easy. And my client's name is Somnia. That is not a hard keyword to search for, and it's not the sort of thing that's going to generate a lot of false positives. I'm not saying that Somnia is the only keyword they would have to use, but there really aren't that many. CAPC along with agreement, again, pretty narrow keywords, and we can be very efficient about trying to nail that down. But it's very hard for me to imagine that we're talking about voluminous records over a short time frame with easy keywords. So I really think that that's been overstated. But the fact is we're guessing at it because they didn't supply any affidavits or evidence to establish what sort of burden would be associated with this. And that's part of their obligation on a motion to quash. But I just think it's overstated at this point. There are not going to be tons and tons of documents. This shouldn't be a terribly burdensome review process. And so, given that those are the justifications that have been offered, I think the court should reject those and should deny the motion. I'm happy to address any other questions the court has, but I don't want to belabor it either.
I had troubles a little bit. Don't worry, I got 99% of Mr. Eldridge's argument, but he had bad audio. Did I understand him to say that the arbitration is expected to take 1 day?
4 days.
4 days.
4 days, Your Honor.
Okay. All right, thank you. The defendants don't really have a say in this, so you don't wish to be heard, correct?
No, I have nothing to add and no objection.
Okay, Mr. Eldridge, do you want the last word here?
Yes, please. Thank you, Your Honor. So what I didn't hear from Mr. Myers is, I think, 2 important things. One is he willing to compromise at all anymore? Or does he just want these documents now before the arbitration hearing, which is not consistent with what he suggested yesterday. But I also still haven't heard precisely why RAM is in such a hurry to get their hands on our documents and force us to have to search for them before, say, even and produce them before mid-June. Again, we're willing to do it. We just want a level playing field on the arbitration proceeding. And I hear what Mr. Myers is saying about how we all have busy dockets, we all have different cases, and this should be treated just like we have another case on our hands that we're satisfying or meeting deadlines for. But that's not exactly really, I think, a fair comparison, because really this matter is a little bit unique in that we being McLaren and RAM have an arbitration agreement that says we're not going to force each other to exchange documents for purpose of the arbitration. And that's effectively what they're doing. What they are doing, even if they accept these documents immediately after the proofs close, which we think is unfair, jams us up considerably. And that's why the court has discretion to enter an order we think that reaches a fair compromise, and we think ours is the fairest compromise for all parties involved. With that, Your Honor, I'll entertain any other questions that you may have.
All right, thank you. Well, first of all, McLaren has made a waiver argument about this subpoena, and that is that the agreement between the plaintiffs and McLaren has an arbitration clause that limits the parties to 2 depositions and 40 interrogatories. So McLaren says the plaintiffs have waived their ability to issue the subpoena. I reject that as a disposition here, because one, there's no authority for it. Two, I don't have the agreement. It was offered to me, but plaintiffs have said, and no one has disputed it, that the language in the agreement actually is that discovery is only waived in connection with arbitration. And this, of course, is a separate matter altogether. And then finally, I just wouldn't apply that to restrict the plaintiff's right to sue a third party and obtain discovery from a non-party McLaren. So it's in an entirely different context than the arbitration, and I would not restrict the discovery based on that without some authority that says I should or can do that. So I am rejecting that argument. The non-party McLaren also argues that this subpoena is overbroad, unduly burdensome, oppressive, and not proportional to the needs of the case. I'm going to address that because I think it also goes to this proposed resolution and the difference in opinion as to whether it's a reasonable resolution or not and what the timing should be. So I agree with the plaintiffs that the requests aren't as broad as McLaren characterizes them. For example, numbers 1 and 2 are limited to the staff letter and the surgeon letter. And also, I'm glad that this was brought up because it was what I was thinking as I was reading the briefs, and it wasn't in the briefs, but as far as I know, the facts, plaintiffs and McLaren weren't associated together until their association, that is what this case is about, and that was for a limited period of time. So it seems to me that even if there are some requests that say all documents, they would be very limited to those pertaining to the plaintiffs, which they are limited that way, and they'd be limited in scope because of the short period of time relatively that these parties even had an association with each other. And they are directly essential to the plaintiff's claims in this case. So I don't think that they are burdensome, oppressive, and not proportional to the needs of the case. But even in addition to that, the plaintiffs have offered to meet and confer, and that's been discussed here today too, with regard to search methodology and production format that would, in a way that would hold down the costs and lessen the burden on McLaren. So I, again, don't see these as overly burdensome, oppressive, or not proportional to the needs of the case. The McLaren also mentions privileged, confidential, or proprietary. The subpoena doesn't seek privileged communication. There's a stipulated protective order in place. If that doesn't serve McLaren's needs adequately, it could certainly be modified. I haven't looked at it, but it was stipulated. I think I signed it, but I mean, I didn't study it in detail because it was stipulated. So I think that addresses that. So, and then finally, also McLaren argues that the documents should be sought from the defendants, but again, I've looked at the requests, and what the plaintiffs are getting at is communications. A lot of these are about communications that are made internally at McLaren, and they go directly to what caused McLaren to terminate the agreement. So they are not documents that would be readily available from the defendants. So let's go to the proposal for solving this, because I understand, even though I'm rejecting the waiver argument, that there is this, how do you get around the arbitration agreement and the limited discovery, and then you file another lawsuit and bingo, you get all the discovery from McLaren anyway. And, that does seem a little unfair, but, I think that the proposal of not waiting to search until after the arbitration, but starting the searching now, especially if the attorneys will meet and confer in order to pare things down or focus on search terms. if that's needed still. I don't know that it even is, but I think that's a very reasonable and fair alternative, with then the documents to be produced after the arbitration is complete. So, is it burdensome to start the searching now? I really don't think that it is. Again, these can be, search terms can be agreed upon, things can be agreed upon as far as format goes. I've discussed the overbroad, unduly burdensome argument just overall in the context of the subpoena, and I don't think that it is. And, with all due respect, I'm sure there's preparation that goes into the arbitration, a 4-day arbitration. But I don't think that the practice of law would stop in order to only prepare for an arbitration. And I think that given the nature of what's requested in the subpoena, it's just not unduly burdensome to ask McLaren to begin the searching and have the documents ready to produce, so that we can avoid any unfairness here, ready to produce when the arbitration is completed. So for those reasons, I'm denying McLaren's motion for a protective order and to quash the subpoena. And I am ordering that the attorneys meet and confer as necessary to, again, clear up any disagreement that may arise with respect to search terms, make agreements on format in order to make this go more smoothly and easily, and then for McLaren to begin the search and be prepared to produce the documents at the conclusion of the arbitration. Are there any questions?
I do have
I
a
have
question.
one, Your Honor. Oh, I'm sorry, go ahead, Roger.
We may have the same question. Your Honor, you used the phrasing complete as to the arbitration a couple of times, when the arbitration is complete. And what I had been proposing is at the close of proofs. So if it goes 4 days, then at the end of the 4 days. And I just wanted to make sure that we understood what you were ordering, because there will be post-hearing briefing and there'll be who knows how long an award takes. And so I just want to make sure I understand what you ordered.
Yes, no, I was thinking in my mind that the arbitration ends when it ends, when the proceeding ends. But I understand there's post-proceeding briefing and things, but I did not mean at the end of all of that. Close of proofs is fine. I think that addresses the unfairness issue.
So if I may, Your Honor, just to maybe, I don't want me to put too fine a point on it, but maybe it requires it. Sometimes we work best with actual deadlines. So the hearing is scheduled to take place May 24, 25, 26, and 27, with a potential 5th day, if necessary, on the 28th. The 28th, I believe, is a Friday. Could we have until the next Friday to produce the actual documents and turn them over? Or are you ordering us to turn them over, say, Monday of that following Monday? I just want to make sure we have a deadline in mind when actually we're going to be expected to produce.
I thought Monday, because if I'm ordering you to begin the searching and be prepared to turn them over, then I don't see any reason why Monday can't work.
Okay, I just want to make sure we're clear and that the order is clear.
Yes.
If the proofs end on the 27th, the 28th becomes the very next business day.
Let's just say Monday.
Okay.
Let's just say Monday and make it simple, hopefully.
Thank you.
Thank you, Your Honor.
Okay. Thank you.
Your Honor, do you want us to propose an order for signature?
Yes.
Okay, we'll take care of that.